Negligence means failure to take proper care. So the act could have been done, but it was not done within the proper manner. So once we are relating this to medicine, every doctor or every healthcare provider knows that if he doesn't take proper care, he's much more likely to injure or cause harm to his patient. So whenever you are directing your actions towards the patient, you should know that if I do not take care, I'm going to cause harm. A lot of students watching me will know that this is known as a foreseeability test. And that places what is called a duty of care on you to exercise reasonable care in that particular form of treatment. So it's not always about neglect to do. Sometimes the act may be done, but it may be done improperly.
Okay. So the medical facility or the medical professional has a duty of care towards the patient who has come to their facility. And that duty of care, they have either failed or deviated in the standard in providing it. So we say a malpractice has occurred or negligence has occurred.
Exactly the point. So there is always a minimum standard that every person directing his action, they are supposed to apply. In some countries, the standard is higher than others. Of course, when you go to government hospitals called the Bukamfanoche, and you have a mosquito bite, this might not be a case for you to sue for negligence if, let's say, you suffer malaria as a result. Probably in England or in the US, that would be a case of malpractice or negligence. So the standard is a bit relative, depending on where you are. And the court sets the standard based on the existing socioeconomic conditions of the place. So the standard of care in Ghana may not be the same standard of care in the US, but there is a minimum acceptable standard that every health professional must comply with. And when it falls, your action falls below that standard, that is why we term in law that you have been negligent.
As always, this is the law. It's your legal lights. It is your health law. And we're doing part 2 of medical negligence. And I say part 2 because for this year, because as you have followed the show, this will not be the first time we're doing a program on medical malpractice, or what is broadly, generally referred to as medical negligence. And in the last installment with Albert Jemfi, we just brought you a sneak peek into that, about the doctors or the health professionals not meeting the standard of care or deviating from that standard of care expected of them when you go to the health facility. And that results in medical negligence because you have suffered injury. You have suffered injury as a result of they not meeting the standard of care or having deviated from that standard. And therefore, you go to court. Sometimes the doctors are reported to the Medical and Dental Council, and some actions are taken, and sometimes it ends up in the courtroom, and if successful, compensation is paid. Now, today we have someone like Dr. Justice Jansen, who wears the 2 hats as a medical practitioner, senior one, and a lawyer. Thank you very much, Dr. Edward Adodankwa, for making time to join us on the law.
Thank you, Samson.
Great. So, even though we are continuing from where we left off with Albert Jemfi, let's have your perspective as far as the basics are concerned. How does medical negligence manifest itself?
Thank you very much, Samson, for the opportunity. Healthcare, as it is a human institution. We have different players at stake, different issues at stake, and sometimes you have good outcomes, other times you have bad outcomes. It is natural, and it's not all bad outcomes that are necessarily as a result of medical negligence. So there should be a minimum standard to determine whether this particular sort of bad outcome resulted from staffs necessarily meeting the standards or falling below it or standard, whether intentional or not, is irrelevant.
I get your stress.
Right. As a result of this shortcoming, some harm, sometimes even death, has been occasioned. And the harm caused, in fact, that's more important to me, that harm caused is directly attributable to the shortcoming. Therefore, let's find a way to compensate or bring the patient up to, as far as money can do, how we can compensate to bring the person to the standard expected.
Where death has not occurred.
Where death has occurred.
Right. So, once again, I intended for you to benefit from some sort of, call it a repeat, by way of getting you not to miss the real point from where we are starting. He has different perspectives that he's going to share with us. So, there's a standard of care every health practitioner is required when they encounter a patient at the hospital in providing them their needs, the reason they are at the hospital. If there is a failure to meet that standard, or there is a deviation from that standard, then as a result of not meeting that standard of care or deviating from that standard of care, there is injury. And as he just said, there could actually be death. When that happens, we say there's been medical malpractice or medical negligence. It could be as a matter of a mistake. It could be that, as far as that person is concerned, that's the best they have done, except their best is not up to the standard. And then comes the issue of compensation. What are some of the very typical situations that you have encountered wearing both hats that represent medical malpractice?
So let me clarify. Malpractice is a general umbrella.
Okay.
Now, medical negligence is one out of that.
That's right.
There could be other ways, and it could be criminal, it could be other misconduct. The MDC will handle that. And then when it is negligent, we go technically by the definition. So about a month ago, a case came to me. A man who was found unconscious by a taxi driver was sent to a private hospital. The doctor on duty was called. He looked at him and said, send them to a referral, sent to Confanoche. The man died. The question is, was the doctor negligent? So we applied the basics. A doctor-patient relationship is well established. A doctor owes a duty of care to the patient. That is it. Then you move on to the standard expected, and I'm sure we'll have time to expatiate more on that. The standard expected will be what has been agreed upon or what is recognized by a respectable body of medical opinion. And that was what the case of Bolam did establish. And I must say that's the minimum to meet. Then you move on to establish whether what this body of medical opinions or medical professionals have agreed, whether it is reasonable, because we are having instances where there's a clear case of negligence. Some doctors are able to come in to defend their colleague that it was not, that's what we do, that's what can also be done. But we realize that some of them may not be reasonable at all. So we subject to some logical analysis, and that's the Bolito test. So you come to our health setting. When an unconscious person is brought to you, what do you do? And whether this doctor did that? At least there are some basics to inspect the airway, to ensure there's good circulation and all that. Then at least being an unconscious patient, you check even the sugar. These were not done. So when the patient died, a case of malpractice or medical negligence may be brought.
Right.
Except if the autopsy was done and it's established that the patient was dead around the time the doctor saw, it means it wasn't the recklessness of the doctor that caused the death anyway. He was dead already before being brought there. In that case, it will not be medical negligence.
All right. You're still here on the law. It's your legal light. It's your health law. I was getting to a questioning. I had to think about it again to be sure if I could ask it or not. So you mentioned the MDC. Let's quickly explain to people who that body represents before we move on.
MDC stands for the Medical and Dental Council. That's a body established by law under the Professional Regulations Act 2013, Act 859, and they are regulating medical doctors, anesthetists, physician assistants. They see to it that we live by certain minimum standards of conduct. When there are issues of misconduct, it can be reported to them. They will investigate and they will bring some finality or justice to the people involved. They are responsible for our registration, our licensing. There are some minimum courses to update yourself in order to satisfy them for your license renewal. So they do quite a number of these. And whenever you are reported for misconducting yourself, doing what you are not supposed to do, they will investigate, and if necessary, they will recommend sanctions. And indeed, they can even suspend your license. They can even get you out of the register, among other options available.
Just as we have for lawyers, the General Legal Counsel.
Exactly.
If you do something that is not in accord with your code of ethics as a lawyer, you could be reported to the General Legal Counsel.
Exactly that.
They would hear the complaints and find out if you have erred. If you have erred, they could say that you don't get to practice for a number of years or you lose your license completely.
Exactly.
Right.
Exactly.
Now, you have started, like, in my encounter with a number of professors in this area, they never start a conversation without mentioning the case of Bolam.
Right.
You mentioned Bolam. Use Bolam to illustrate for us to understand what is that standard of care and when can it be said not to have been met or that there had been a deviation from it.
Thank you. So Bolam test is a test that spells out the minimum standard of care. What Bolam test simply says is, as doctors practicing in Ghana, we do not practice in a vacuum. There are standards of training, there are standards of care, there are ways of treating certain conditions, and they are all spelled out in our standard treatment guidelines. Or in the teaching hospitals, you may have protocols well posted on the walls. That these are the minimum standards to meet. And it is a standard which is accepted by a respectable body of medical professionals. It could be in Ghana, we have the Society of Obstetricians and Gynecologists. It could be other such bodies. It could be the GMA, even the MDC itself. So Bolam says that when we have such a standard set, then you need to meet that. If you do not meet that, then it means you've not met the required standard, and that could make you negligent if, as a result of your inability to meet that, it has caused some harm. The problem with Bolam, however, is, and it applies when it comes to diagnosis and treatment.
Right.
But when it comes to information disclosure, Bolam has now been overruled by the Montgomery test of materiality. Now, as indicated earlier, Bolam simply said that, or it allowed doctors to even protect each other. There was a case where a woman had a child in the ward. Then the doctor was called that there was respiratory distress, so he should come and assist. The doctor did not come. Persistent calls were made by the house officer. The doctor did not come. Eventually, the boy died. In court, the doctor said even if she had responded to the call, she would not have put on the ventilation or intubated even the patient.
Which is what the patient was calling
Which is what
to be done.
Yes, to be done. The doctor says even if he had responded, she would not have done that. And that her decision not to do that is what a number of other doctors will do, so it is acceptable. Then the other side also said, no, for a child in that kind of difficulty, that should be done as a standard. So there was a division. Which way was the court to go? And by our NRCD 323, these opinions are just expert opinions, and they do not bind the court or the judge. So what came out of that case, and that was what we call the Nigel Bolaito case, or the Bolaito test, was that then the court should be able to subject these two streams of opinion, all meeting the Bolam test anyway, to a certain logical analysis and find out which of them is reasonable. So Bolam has now been modified by the Bolaito test that even if the body of medical opinion professes a particular practice, it should be reasonable to the court. An issue happened in Taifa where a hospital gave some strange combination of antibiotics to a patient, and the patient reacted badly. There was a lot of vomiting, etc. What the hospital said in their defense was that in their community, they've done a research, and those strange combination of antibiotics is what works for their patient. So it's like me making a mistake by giving about 2 grams of paracetamol to you. You've caught me as a mistake, and I said, no, in this hospital, in this community, that's what works. Now, one, is that what the respectable body of professionals say? That would be one. Even if that's what they say, then let's subject it to a logical test, whether it is reasonable. So that's where Bolaito came. So now Bolam has been modified by the Bolaito. But then when it comes to information disclosure, it does not apply at all. And I'll explain that briefly. Something before you take somebody to theater, the patient should consent. And consent should be based on information you've given the patient. And you are supposed to make, by our patient charter, full disclosure.
Full disclosure.
That's at 851-167. Yes, full disclosure. I disagree with that. I think there should be a need for some amendment. Something nobody knows fully every information about any sickness, including malaria.
To the extent available, make it available. That's full disclosure.
So there's something should be done about it, else a patient could use that against us. So now with the Montgomery, what Montgomery is saying is that disclose what is material, not necessarily fully, not everything about it that will be material or necessary. You understand? Yes. So disclose all that, and then when the patient has all those information, he can decide whether to go by that or not. In this Jabin case, it was about whether to do cesarean section or probably to go by normal vaginal delivery. They opted for normal vaginal delivery. The question to ask is, did the patient consent to that? Was she aware of the risk? Beyond 42 weeks, there's a lot of risk with that pregnancy. Was she told? They have denied they were not told. So that is another angle of negligence that could be explored.
Please hold on for us. You're still here on The Law. It's your legal light. It is your health law. And our guest is Dr. Edward Adodankwa, who is also a legal practitioner. He's a senior medical practitioner as well. And we're treating Prosecuting Medical Negligence Part 2. Get ready. He just started. He has divergent opinions on almost all the issues that we treat as far as this subject is concerned. We'll be right back. You're welcome back. This is The Law. It's your legal light. It is your health law. And our guest is Dr. Edward Adodankwa, Esquire. He's senior medical practitioner and lawyer. And he just left us, took a break briefly on where he was explaining what is known as the Bolam test. If you remember far back, a couple of years ago when we had Dr. Ernests Owusu-Dapa, who is now Justice of the Court of Appeal, he began with the Bolam test. Bolam and Friend Hospital Management Committee, 1957 case. And it sets out a standard. He has laid it down, the standard of care. The test assesses whether the doctor's actions meet the standard of a reasonably skilled and competent practitioner in their field. And 2, there is peer review. The court will normally consider what a responsible body of medical opinion would deem acceptable if what the doctor or the health practitioner has done is subjected to what the body of professionals will say. If it meets what they will say, then it will stand. If it doesn't, then it will constitute medical negligence or malpractice. He wants me to use negligence rather than malpractice. And then 3, there is no negligence if the doctor's actions are in line with the accepted medical practice, even if other doctors have acted, might have acted differently. And he brought in what is now known as the Bolito test. That's the Bolito versus City and Hackney Health Authority 1998 case, which introduced an additional requirement for the medical opinion to be reasonable and logical. Thank you once again. So, over a period, we have been discussing these matters. You have spoken about why consent is important to meet the care. Why do you think that there are increasing cases of medical negligence in the country now?
A lot of factors could explain that. Off cuff, one may say then probably there are increasing cases of medical negligence. But it may also be said that people are getting to know their rights. A lot of education is going on, and people are realizing that some of these things, if we don't take it up and help sanitize the system, we may continue to have our worst nightmares happening. So yes, it's increasing, and I think it's good in the long run. Ultimately, it is good as it will help us, be on our toes. Other factors include, these days there's a lot of distraction as well. A lot of us use our phones in the wards. There's all sort of distractions coming in here and there. So sort of measures have been proposed. Some are working, some are not. But these technologies have also become part of our work anyway. So these are all some of them. Now there are also a lot of monetary incentives as well. And now everybody is looking around. Hey, what did they do to me? Can I test it? Can I go to court? So the cases are increasing, and I must tell you, some of the complaints are also frivolous, if I may put it that way. I've had a case where a person goes to hospital, he's diagnosed well appropriately. Later, there's a different diagnosis, and he says, hey, then that was negligent. I was not diagnosed. There's a German case where a doctor...
In the case that you just mentioned, the person didn't suffer any injury?
Not at all.
So what's the complaint about?
The complaint simply is about that a different sickness has been diagnosed, and he thinks it's negligent because he should have been picked in the first instance. But in the first instance, you went to different complaints, the tests for that complaints were done, and H. pylori was picked and treated. So if you go somewhere else for another complaint and something else is picked, you can't blame them to be. You see, when it goes on like that, it distracts and sometimes demoralizes the health workers. Because there's a case, and that was a German one. The doctor told the woman, I've seen something around your cervix, the vagina. You should come for some further tests and some vaccination. The lady did not go. 4 times it was written to her to come. She did not. Eventually, she died of what the doctor suspected. The children sued. And when it was pointed out to them that 4 occasions they were invited to come, they said the doctor did not say it with enough seriousness. You can imagine. So if that becomes a basis of a suit, I mean, obviously it goes off the window. So the negligent may be used loosely, but it's a technical word. And until all those elements are proven, there cannot be negligence.
All right.
It could be misconduct, but if causation is not established or if harm is not established, it cannot be negligence.
You introduced the word causation. It's not ordinary. So we say if causation is not established, if harm is not occasioned. Explain that.
So causation simply means what the doctor did or the shortcoming of the health workers, did it cause you harm, or is that what caused you harm? This is better illustrated by the Barnett versus Chelsea Kensington Committee case. A patient went to the hospital vomiting, and the doctor thought he was tired, so they should come later. Obviously, that was loosely negligent. The following morning, the patient died. So one would say the doctor's acts or shortcoming caused the death. But they did an autopsy, and the autopsy established that there was an arsenic poisoning. So which means what the doctor did, though bad, though inappropriate, falling below standard, that wasn't the direct cause of death or even a remote cause of the death. Because at that time, there was no treatment for arsenic poisoning.
So that will amount to misconduct.
That would amount to misconduct.
But not
negligence.
To which someone can sue and
Exactly.
get compensated for.
Exactly.
If it's just misconduct, then they can go to the Medical and Dental Council and make a report.
Exactly.
What will such a health professional suffer as punishment?
So if the MDC invites you, they will hear you out and they find you guilty of what you are accused of. A range of punishments are available. You could be fined, you could have your license suspended, they could assign you to go and learn some basics from some other senior practitioners. And in the one case, Abraham Sandy, he was even struck off the register. You can't even practice at all.
Okay.
Yes.
All
so
right.
all those are options available to patients who wants to do that.
Let's establishing again, what could be the factors today that are compelling people to sue, rather than what people used to think about more, famanyame, or, you know, this job is difficult. It's also prone to human error, so let it go. What today are the factors that compel people to want to sue?
It will surprise you, Samson, that a study has established that how patients were treated is one of the factors that push them whether to do this or not. Were they treated respectfully? Were their inputs taken or at least even listened to? Were their dignity upheld while they were there? A patient comes to me and he tells me, sue them for 7 million. And he tells me, it's not the money. I don't want the money. I want them to be on their knees. I want to collapse them because they were disrespectful to us. When we were telling them that my wife was suffering, they did not attend to her. They said, you are not a medical person. That sort of disrespect or that sort of apparent rudeness from us. And sometimes you see, it cuts across. Customer service, it's a very anemic, systemically malnourished in this country. All the public sectors, it cuts across. And when people come and you treat them like that, the least error. Because when they went to a different hospital, though the woman was saved, there was another sort of negligence there. They tell me that, no, yes, my child died there, but I saw that they tried. They were nice to me. They treated me respectfully. But the other people, no matter what we said, they will not take it and they will say, keep quiet, you are not a medical person. These things infuriate clients.
Yeah.
At times, something bad happens to them, they need to air something else.
That's
Sometimes
right.
they are drawing our attention to some errors.
There's this police officer whose wife went to deliver in this hospital, and just a week or so after, or just shortly after, they discovered some things. And they brought it to the attention of the health facility.
Right.
And they said, oh, it's nothing. Just give yourself a couple of weeks. It will be okay. Then by the time they realize it's developing to cerebral palsy. And they are going back to these people and they don't go there happy. They go there with a sense, as you have just said. So how the patient is treated is important.
A lot. Very, very important. I was admitted to a hospital in London some time ago. Something by what I know today, I would say what they did for me was not much. It was some cold, they gave me some paracetamol, one infusion. Medically, it wasn't much. But something I can tell you, the treatment, the customer service, 5-star. Why are they treating this like that? And why? It wasn't because I introduced myself as a doctor or anything. No.
They'll explain everything to you.
Everything to you. They have time for you. Why can't we do the same? So at times, some of these things infuriate clients. That case, finally, I managed to talk to them. They settled for, I think they got about $500,000 or so. But he told me, doctor, with due respect, what you've gotten for me is big money enough, with due respect, but it is chicken change. When he compares that to what he suffered, the indignation he suffered, he told me that that's chicken change.
A good number of medical practitioners watch the law. Please remember that how you treat your patient is very important. They can cooperate with you. They can appreciate and empathize. They can sympathize with you when certain things go wrong because you're only human. But when you don't treat them well, if they come to the facility and they are being treated as if this is just commerce, they are coming, it's their money that is important, it may get to a situation where they will not cooperate with you at all. My guest is Dr. Edward Adodankwa, who is also a lawyer and helping us to discuss the issues of medical negligence. Now, because of what you just said, I will eventually bring you to how we can use alternative dispute resolution to resolve medical negligence, because you have used that to actually resolve some of the situations. But what will you tell practitioners? What should they do to avoid these situations?
Like we said earlier, it's a human institution. Errors are possible. And when they come with complaints, we should calmly listen to them, try and do what we can about it.
Doesn't matter if the one coming with a complaint is not patient.
It does not matter at all.
It's acting violently.
There are ways of handling such people. And as medical practitioners, we even know better. There are ways of handling people. There are ways of calming them down. You listen to them. At times they do that because they feel they are not even being heard.
Because they may have lost a relative.
That is part, yes. So you listen to them, you give them reassurance, you look into it, you keep updating them, you do that, you calm them down. You see, Samson?
The will look into it should not be the Ghanaian will look into it. We'll look into it, and that's the end of it. They don't do anything.
For real, we will look into it.
Okay.
No matter what, because it's in your interest to do that. And a lot of times they go along with us. When they realize you've listened to them, and indeed you are looking at it, then you discuss with them. A couple of these things have come up, and that was the approach. I can tell you in this country, and I say this to the credit of one of the finest administrators we've had, there was a mistaken amputation of somebody's penis in the course of a surgery. You didn't hear of that. It wasn't in the news. Why? Because there was a calm way of dealing with it, settling it, talking to them, and they didn't even see the need to go to court. These things can be done, regardless of how bad the situation or the complaint is. But if you are fighting fire with fire right there and then, when they are upset, they've lost something, they are angry, certainly the result...
Was there supposed to be a surgery on the penis, or how come there was an amputation?
It was supposed to be a hernia. And where we work around that, it's around the same area. So it was a mistake, but as we know, negligence has nothing to do with whether it was intentional or not.
That's right.
Yes. So he could have gone on. But this fine administrator of health dealt with the matter, settled it, and it didn't even come out.
Great.
And we have used ADR, our laws permit that, to settle a lot of these things. I had one done just, I think, a week or two ago, and it helps. And we encourage facilities. When you assess the circumstances and you realize clearly there are some errors, you don't allow the matter to go all the way. There are ways of settling, and I think they should approach professionals.
So in the ADR, the alternative dispute resolution, are you going to admit to the patient that, yes, it's my fault, I did this? How are you going to go around it to get the patient to be satisfied in the process?
ADR does not necessarily go with admitting, because even in the end, when we sign the documents without prejudice, we say that what is given you does not necessarily mean we admit liability or fault. Yes, but then we are able to look at it to find a win-win situation, a way of resolving it such that, because if going to court, something it takes a lot. It's costly, it will take time. Take the rich case. Yes, 4.5 million, but it took, I think, 4 or 5 years. Take this one, the driving case. It also took, similar. So at times, it's costly as well. So if you do not have the means or you don't want certain things exposed, look at this driving case. One of the things out there, and which I think fits in for ADR, even the abortion history of the woman is in the judgment. Everything is there. So confidentiality becomes an issue. And we highly recommend that we resort to ADR first. If it does not help, then probably we proceed.
Because ADR also comes with confidentiality, yes, which is like very important in it, confidentiality. And the parties in the ADR must also understand that what is discussed to resolve the matter amicably cannot even be used in the courts, right? Thank you very much. Now, in the US and the UK, when medical negligence matters started increasing, there was an approach because they realized that the Hefty Awards, as in the damages, would collapse the health system. So they took some steps about it. Do you feel in Ghana the awards are beginning to look hefty, are beginning to look high, and could threaten the survival of the health facilities?
This month or this year has witnessed, I think, the strongest messages yet from the bench that we should prepare, and that's where we are going. In fact, I've seen the statement of Amegacha JSC, then I think 2020 in the Kwabena Nani case, where he said initially they were frugal with cost. And
they were very frugal.
Right.
They were giving small money, which was really nothing.
Exactly, because in fact, if you look at the 37 case, where I think for the first time you saw 1 million Ghana cedis awarded, even if you look at it very well, you realize that it still doesn't cut it. It was still frugal. So now, with these two cases, something that looks like that's where we are going. I've been to Jamin Hospital before. You get there, sometimes you look at the place, you are expecting this hospital to produce 3.5 million. They can't. So while we think that, yes, we should punish the hospitals if they go wrong and all that, we should also not cripple the system. Because in your attempt to do justice for an individual, you should not do injustice to the masses or to the public. Because now, if Gemfi goes ahead to attach their vehicles and all that, how are they going to the hinterland to do their vaccinations and just the health education and the weighing and all that?
They're a government hospital. It's the whole government. The government can pay.
So there's a,
they have appealed the decision, and I'm sure the appeal is more to do with the quantum of the award.
Yes, but there are other aspects I also expect them to fight harder on. I think some of them are matters of fact. I've spoken to both sides, and it looks like maybe they may contest some of those. One side I will pinpoint has to do with the causation side, on where the judge saying as a result of the tear, the baby was lying in a pool of blood, and suggesting suffocation. The baby, the fetus could not breathe, and therefore, something going back a bit into some of the basics of medicine and obstetrics. Babies already live in water. They already submerge in water, what we call the amniotic fluid. They don't breathe through the amniotic fluid. They are breathing, or they are also supplied by the placenta through the cord, the umbilical cord. So even if it's covered entirely with blood or water, that's not the source. You are giving
the Attorney General ideas as to how to go about the appeal on this matter.
It does not cause, that cannot necessarily be the cause of asphyxia unless they are able to establish that there was a detachment of the placenta. And that, if that had happened, the baby would have died. So that too did not happen. So I'm hoping they explored some of these areas.
Right. You have a concern. Your concern include that we have already hospitals that cannot even afford to get sufficient beds, what we call the no-bed syndrome. You have hospitals that have the need to do a decongestion, hospitals that may have to refuse, people, and so on. And in such a situation, when these monies are coming against them because they are being caught up in negligence, then it's going to cripple them.
Yes, because some of these hospitals being common gloves at times is an issue. So if they are able to push all their NHS subventions into payment of this, what are they going to live on? I mean, commodities, consumables, etc. So it's also on the higher side.
Yeah, but you should be preaching to the hospitals too.
Definitely.
Yes. What will you tell them? What are the lessons they have to be taking?
Something, documentation. And people should be careful with what they do. Rules are rules. If the facts as admitted in the judgment happens to be true and a reflection of the reality that happened, I'm afraid I must admit that we let them down. It shouldn't have been that way. If they are going to contest those facts, that's fine. But if they accept them as they are, then it didn't look good. And we tell people that now the cases are coming up, people are not stopping, and this will encourage more people to come. As you know, the limitation that people have 3 years to even bring such suits.
Yeah.
So this can even remind others to bring their cases. We should treat patients well. We should do what we have to do. We should have a full regard for life. we are all potential patients.
I'm someone who watched us the last episode on medical negligence and approached me about a situation, but it's been over 6 years. So the 3 years have elapsed, the 3 mandatory years within which you can sue have elapsed, and another 3 years have come. If somebody like that came to you, what advice will you give them?
Some say there's a way. There's a way. Now, according to the Limitation Act, when it elapses, the judge can still consider the circumstances, and if he thinks it will be fair and just to both parties, he can allow it. There's a little discretion there.
Where the cause was manifest from the very word go, even after 3 years, even after 6 years, a court can give
now, because you mentioned 6 years, let me come there. Negligence, you could come in 2 ways. There's also the contractual side to it. Because admitting a patient...
the phone lines have been activated. You can call us with your questions right now, and Dr. Ernests Dankwa will answer them for you. So you can call us right now. Please go ahead.
Admitting a patient is sort of an implied contract also signed. And if you, where there's a contractual element, or if you come by that, it's actually 6 years. Limitation Act. Yes. So they can come by that and invoke the contractual provisions.
But it's a clear question of thought.
Yes,
and it has to be 3 years.
It's taught, but then taught can also be contractual. Yes, so you can invoke that to do so. And that will say that the courts also have a discretion in that area. And
but in this example, I'm talking about after 6 years. It's not within 6 years.
After 6 years, that would be difficult.
After 6 years.
That would be difficult because the contractual element allows it up to 6 years.
All right.
Yes.
Interesting. So you can call us now and ask your questions of Dr. Ernests Dankwa to shed lights and give some explanations to you on what to do. Do you feel that practitioners, medical practitioners, are getting to be a bit more careful in the sense that when there's something they ought to do, they'll rather say, I'm afraid this can happen, so I won't want to do it?
Exactly, and you are walking into the realm of defensive medicine, as usually portrayed.
Defensive medicine?
Yes. This is where...
Or even refusal?
Even refusal, yes. This is where a medical practitioner makes decisions or judgments, not necessarily because it will benefit the patient, but simply because that will be the least path of resistance. That's what will bring him less trouble. You understand? So at that point, the interest will be on him and not necessarily the patient.
So they can decide to refuse to accept a patient and say maybe because there's no bed or something, or what you just said?
That is typically transient. There are two types of defensive medicine.
2 types. Let's get to this anonymous caller from Mataeko. Hi. Hello. Please pay attention to your phone. Hi.
Good afternoon.
Good afternoon. Go ahead.
Hi, good afternoon. Hi, good afternoon. Yes. Yeah, I have this experience with a medical doctor who... I had an experience with a medical doctor.
Okay, so the best thing to do, if you're calling, stay direct, listen to us on your phone and not on whichever platform you are watching the show. If you do that, this is the kind of situation you will have. Listen directly to the phone that you are using. You can actually put your TV set or whatever device you're using to watch, put it off so that we can have a direct interaction with you. Once it's stable, we can get back to him. Yes, you are saying something.
There are 2 types of defensive medicine. There's a beneficial defensive medicine, and then there's also the detrimental defensive medical practice. With the beneficial, it's like, for instance, this Rich case, that happened. Rich has now put in place measures. Now, we will make sure that we add either fragmin or the clozine to the drug so that we avoid that situation after every surgery. When Sueba case happened, Konfanochi placed measures in place. So that is also part of defensive medicine. The doctor will say, now I'm going to make sure I do all my recordings so that I will avoid liabilities. That's the beneficial side of defense.
All right, hold on. A bad case has helped them to become proactive, to do certain things extra. Kwame, you're calling up from Siani. Let's hear you.
I wanted to ask if a medical officer gives maybe not at a hospital, not at a facility, maybe a patient calls you or something, and then you give maybe a prescription on phone, maybe through WhatsApp, any of these informal means, can the patient take you on as a medical officer?
Kwame, you said a patient. Does that mean the doctor or the health practitioner already knows this patient? Is that the case, that they have come to the hospital already and they are calling you, or what?
Oh, not necessarily they have come to the hospital. Maybe it's a previous patient, they have your contact or something, and they call you maybe saying that I have this and this and this
or it's
problem,
a friend.
and you give them a plan on phone.
Okay,
maybe
thank you. So that's a sort of free consultation, right?
Yes.
All right, thank you.
So the detrimental defensive medicine is where, like you are saying, they decide they will not even accept the patient at all. Our ward can take 20 patients. When we take an X-ray and something happens, we'll be in trouble, so we will not accept at all. But that is not acceptable. In fact, literature suggests it does not happen. It becomes a knee-jerk reaction when issues like this happen. But it does not continue because regulators will not allow that. Under our constitution, we have the Chapter 6, Directive Principles of State Policy. Right to health is a right to the citizenry. And if you go by the words of Datiba JSC, he said they are justiciable in the Lotto case. They are justiciable until you prove they are not. So if they take you on to either the African court or the ECOWAS court, the country could be in trouble. So those do not happen. Now, to Kwame's question.
Okay, before you go to Kwame's question, we have Ernest. Ernest is calling from Kumasi. Hello, Ernest. Let's hear you.
Hello, Samson. Good afternoon.
Ernest, go ahead.
Oh, okay, yeah. Dr. Eddie, do you remember me from Kumasi South Hospital some years ago? I'm a physician assistant, actually.
Right.
Samson, I wish to deviate slightly on the issue of medical negligence, if I'm allowed. It's a general problem about the practice of physician assistants and the issues they are having with medical and dental council.
Please go ahead.
Yes. At a point, the registrar from Medical and Dental Council declassified physician assistants as not being medical practitioners. And I feel it's something that can have legal consequences. There should be a clarity on that. Because there is a high court ruling on that. But as time goes on, he continues to declassify physician assistants as medical practitioners. And that is something we need clarity on.
But you said there's a high court ruling. What does that say?
Patients may take advantage of that.
What does the ruling from the court say?
I cannot be specific on it, but I learned there was an issue involving physician assistants who signed a document that the MDC that time felt they weren't medical practitioners to do so.
Okay, I remember that case. Thank you very much. So first with Kwame.
When friends, acquaintances contact you on phone and you decide to help, something you are not under an obligation to attend to them or to assist them. You can direct them to go to the hospitals. Once you decide to assist, the standard arises. You are supposed to live by that standard. And therefore, if you mislead them or you become negligent in the course of you assisting, yes, you can be taken on.
Right. He has a problem, Ernest, with the Medical and Dental Council declassifying physician assistants.
Something, as far as I know, in the Professional Regulations Act, it includes them as people practicing medicine. It includes them. Now, the difficulty with what he said and why Divine will be serious with this is that sometimes you go to court, a doctor has come to testify or to, as a witness. And the first question counsel will ask you is, are you even a specialist? Why did you even sign when specialists are there? This is done to even senior medical officers who are not specialists. So when you are a physician assistant and you go in to do that, you see, you are jeopardizing even the case of your patient. And we've seen this play out in court severally. So when those people are there, when the seniors are there, you don't touch them. But as to the semantics as to whether they are or not, I know they are considered to be people practicing medicine.
Interesting there. Thank you very much. This has been The Law. It is your legal light. It is your health law. And we have been interacting with Dr. Edward Adodankwa, who is a senior medical practitioner and also a lawyer. Who is... Hi, Sam. Where are you calling from?
I'm calling from Tamale.
Tamale. Let's hear you quickly.
Yes, please. Something you know, I'm a Muslim by tribe, and sometimes
You are?
a Muslim by tribe, by religion rather. I am a Muslim by religion rather.
Did you hear that?
Sometimes we believe in
sorry, Sam. I need you to speak up. I can hardly hear what you say.
Okay. I'm saying I'm a Muslim by religion.
Okay.
So my question is that we Muslims we don't want other or to check our wives if they are pregnant, their cervix, or maybe check through their vagina to see most of the things. So sometimes you prefer the female one doing that for you. But as a patient, or maybe as a husband of your wife who is pregnant, can you decide can you tell the doctor to allow a female one to check the service, whether the service has opened for the doctor or maybe or for the midwife who is a male, rather than he or she he checking it himself.
All right.
And if the person refuses, whether you can sue or take the person's own.
All right, thank you very much. Doc, yeah.
As a result of the 3.5, everybody is talking of taking that to court. So as you see, a patient has a right to decide who attends to him or her. If you are not comfortable with the particular doctor attending to you, why not? You can always raise that, and they are supposed to listen to you. The difficulty, however, is maybe the whole hospital, there's only one gynecologist, or there's only one doctor who is competent.
Who is a man?
Who is a man. There might be a female there, but she might not have the competency to look at what we are looking for, or to look at what is suspected.
So you have to now exercise the option.
The option.
Go elsewhere.
Exactly.
But you say that they have a right to determine which physician or health professional should attend to them.
Exactly.
So there's no problem.
There's no problem at all.
Okay.
If you are a doctor and the patient tells you, I'm not comfortable, please, you oblige the patient.
But his concluding part, what are you going to sue for? He said, can I sue? The explanation we have given is that there must be a lack of the standard of care in treating you,
yes,
or a deviation from the standard of care in treating you, and it must have resulted in an injury, what we call harm, to you before you can go to court. So in this case, the person, you want a male, you want a female, there's no female, and the male goes ahead to do it. Can you sue because your religion does not allow you to let a man check the cervix of the woman? That's his thing.
You cannot. It won't go anywhere. But he can sue if, upon raising the objection, the doctor proceeds against the consent of the woman, not even necessarily of the man.
So what is he suing for?
It could be assault.
Assault.
Something.
Okay.
If somebody decides not to allow you, if you are denied consent and you do so, it's an assault. And there's an extreme case, a Canadian case, where the doctor brought in a friend. He was doing vaginal examination and brought in a friend, gave the friend a lab jacket as if the person was a doctor.
Oh, no.
To observe. Unfortunately, what they went to court with was assault. They won it at the first instance. It was an appeal that it was overturned.
Okay.
Yes.
But isn't this a bit more clearer? So as we wrap up, what will be your final words, both to us, the patients, and to the practitioners and the institutions?
Something before that, I would say where we are heading towards, it's getting more expensive. The cases will be coming. We hope the facilities will seriously consider the idea of the malpractice insurance. Something like that should be discussed seriously so that we could cover our facilities and also our practitioners. Most of the time it's not intentional, but we know what's at stake. Now, the final words, yes, To patients, I would say they also have a responsibility to us. This would have been case the lady had stayed for about 2 weeks beyond even the date given her for delivery. So she also contributed somehow, and at times this plays out also a lot.
Contributory negligence.
Contributory negligence. So they should also cooperate.
You are still doing the Attorney General's case.
And then also,
we'll charge you. Yeah.
And then also, a lot of them, we also expect them to cooperate with health practitioners. Let's all be civil towards each other. We don't need to get at each other's throat. To my colleagues, health professionals, we all see what's happening. More are coming. I would just ask that we do our documentations appropriately. Let's consider every case, every folder before us to be a potential legal case. And therefore, whatever we are doing, we should document it appropriately and be prepared that in case something come up on it, we will be able to defend ourselves appropriately and make the council's work easier if we do the right things. Thank you.
As for what's to be said to the court, you have already said it. You're saying that you shouldn't give too much. But as for us, we'll say give as much as is necessary to put the person back to where they were, even though money may not be able to compensate in most of the situations. My guest has been Edward Adodankwa. He is a senior medical practitioner and a lawyer, helping us with medical negligence part 2. I'm Samson Lardy Anyenini. This has been The Law. It's your legal light. It is your health law.